Welcome everyone, and thank you for joining our seminar today on understanding and resolving legal disputes that involve Chinese suppliers or business partners. My name is Vince Chi and I am a litigation attorney with Wolster & Co., focused on international commercial disputes. Wolster & Co. has been assisting foreign companies and individuals for over 20 years. We have a team of 15 attorneys who are fluent in both English and Mandarin Chinese. Over the past 5 years, more than 70% of our caseload has dealt specifically with contract and trade disputes between non-Chinese clients and their Chinese counterparts. Some key stats about our track record: we have successfully recovered over $1 million in unpaid invoices and damages on behalf of international clients in disputed dealings with Chinese suppliers. In arbitration proceedings, our clients have achieved a win rate of over 85% when we have represented them. Through our focus on out-of-court negotiations, we have also resolved nearly 600 additional cases without needing to resort to formal legal proceedings. The main goals of today's seminar are to help you understand. Goal number 1. Provide an overview of China's legal framework and what constitutes a valid legal case or dispute according to Chinese law. Goal number 2. Introduce common approaches for resolving issues, such as out-of-court settlement, arbitration, and litigation. Goal number 3. Introduce our innovative hybrid resolution model that combines these methods. Goal number 4. Most importantly, help you determine the best path forward to achieve a satisfactory outcome in your unique circumstances. By the end, you'll have a good idea of how to evaluate if you have grounds to pursue a claim, and be familiar with resolution approaches our firm commonly uses to achieve successful outcomes for clients facing similar issues. Now that we've covered the goals and outline, let's get into the specifics of what constitutes a legal case or dispute when dealing with Chinese suppliers. The first requirement is having a legally binding contract outlining the terms of your business arrangement. An enforceable contract clearly lays out expectations on both sides. While not absolutely necessary, it's the ideal documentation to establish rights and obligations. So what qualifies as a valid contract in China? When assessing if an agreement constitutes a legally valid and enforceable contract in China, there are several key elements that must be present. Consent of the parties: both sides must have voluntarily agreed to enter into the contract without coercion or fraud. Capacity to contract: the individuals signing on behalf of each company must have proper legal authority to do so. Clear subject matter: there must be identifiable goods, services, projects, etc. that are the focus of the contract. Definite terms: essential terms like price, specifications, deadlines must be clear and not ambiguous. Legal purpose: the intent of the contract cannot be for anything illegal or against public policy. Consideration: each side must provide consideration, meaning both make promises to provide value such as money paid in exchange for delivered products. Some additional validity requirements relate to proper form, such as contracts over a certain value typically requiring signing before witnesses or notaries to prevent later disputes over authenticity. Overall, as long as the core elements of consent, capacity, subject matter, terms, purpose and consideration are present, and proper execution formalities were followed if applicable, then the agreement will generally be considered an enforceable business contract under Chinese law. While an official written contract is ideal, I understand it's not always possible. Therefore, let me discuss potential substitutes that can still help validate your claims in legal proceedings. Key documents include communications, purchase orders, invoices, payment records, shipping documents, customs declarations, witness statements, industry standards, and records of past dealings. Let's examine electronic communications in more detail. Under Chinese contract law, electronic messages such as emails and text messages can carry significant legal weight, even substituting for the lack of a signed written contract in some cases. For example, a series of emails between a Chinese manufacturer and foreign buyer contain the following relevant details. Price and payment terms for an order of 10,000 computer units. Specifications for the products including processors, memory, etc. Delivery schedule with ship date within 30 days of receipt of wire transfer. Agreement that the goods would be covered under a standard 1-year warranty. Even though there was no physical contract document signed, a Chinese court accepted the messages as evidence of a valid electronic contract since they documented clear essential terms like subject matter, consideration amount, performance obligations, etc. So in summary, while not conclusive proof, ongoing email, text or even verbal communications can serve to substantiate the formation of a contractual agreement and obligations in the absence of a formal written contract under Chinese law. Another basis for a legal case is establishing a breach of contract by one of the parties. This occurs when that entity fails to uphold their contractual obligations through acts like non-delivery of goods, providing substandard quality products, or missing deadlines. Documents showing such a failure can help prove a clear violation of the terms. Let's look at a scenario. A manufacturing company in Shanghai agreed to produce and deliver 500,000 custom widgets to an Australian importer by December 1. The contract specified that the widgets must meet certain quality control standards for strength and durability. On December 15, the Australian company received only 400,000 widgets from the Chinese manufacturer. Additionally, during quality inspections the following month, it was discovered that 10% of the widgets received failed to meet the durability standard and broke easily under minimal stress. In this situation, the Chinese manufacturer breached the contract in 2 ways. 1. Late delivery, by delivering 100,000 widgets past the December 1 deadline as agreed upon in the contract. 2. Substandard goods, by providing widgets that did not conform to the durability specification stated in the contract. 10% is a significant percentage here that would likely be deemed a material breach. So due to these clear violations of its obligations defined in the signed contract, the Australian importer would have grounds to pursue a breach of contract claim against the Chinese manufacturer in this example dispute. To summarize these key qualifying factors, a legal case necessitates either the existence of a legally binding written contract, or evidentiary documents that can substitute for the lack of an official agreement. Additionally, demonstrating a contractual breach by one party through their failure to perform as stipulated provides grounds for a dispute. With this foundation regarding applicable Chinese law, let's progress to discussing alternative resolution pathways available. Let's start by going over some basic concepts of dispute resolution. There are generally 3 primary methods parties can use to resolve legal disputes between them. The first is reaching an out-of-court settlement through mutual negotiation and agreement. The second is arbitration, which involves using a neutral third-party arbitrator to make a binding decision. The third is litigation, which means filing a lawsuit and going through the court system to obtain a judgment. Each approach has its own procedures, benefits, and downsides that are important to understand. An out-of-court settlement is typically faster and less expensive but requires compromise from both parties. Arbitration can be quicker than litigation and provides a definitive resolution, but the arbitrator's decision is binding. Litigation can fully establish your rights but will take more time and legal costs. We'll explore the key features of each method shortly. This background will help you determine the most effective dispute resolution strategy for your unique situation. Let's now discuss out-of-court settlement as a dispute resolution option. The first critical step is one party expressing their willingness to explore alternatives to continuing down an adversarial legal path. As lawyers, we often recommend our clients consider informal resolution options early to curb costs and challenges that come with protracted litigation or arbitration. Signaling openness to discussions in a carefully drafted letter can initiate productive dialogue. It conveys your cooperation without conceding legal positions. As representatives, we then schedule an initial meeting to sincerely listen and outline next steps. At this initial meeting, each side calmly presents their respective cases and evidence collected. All parties are invited to voice perspectives and understand mutual interests that transcend stated positions. This exchange aims to transition talks from accusations towards problem solving. As counsel, my job is ensuring a productive discussion where interests, not just conflicting stances, emerge. With a comprehensive overview shared, we shift focus onto compatible goals and areas open to compromise. This new stance sets the proper framework for further cooperative negotiations. While accommodation does not equate settling, establishing this cooperative spirit encourages exploring mutually satisfactory options, the goal of any settlement seeking to preserve business relationships whenever reasonably possible given circumstances. By proceeding thoughtfully through these initial confidence-building steps, settlement can unfold via cooperation and innovation rather than attrition. This improves chances for parties to craft tailored, interest-based resolutions within proper legal standards whenever amenable to circumstances. From there, direct negotiations take place. Direct communication between the key principals and their legal advisors is the optimal starting point. With my client's authority, I would participate in these negotiation sessions to provide guidance on legal risks and opportunities. Some factors we consider in planning the discussion format include the personalities involved, complexity of issues, and need for an impartial intermediary. If direct talks reach impasse, mediation with a neutral third party can breathe new life into stalled negotiations. As the party's lawyer within these sessions, my role spans several important functions. First, I present our legal position, evidence, and bottom-line terms to seek resolution. But I also actively listen to understand the other side's perspective and identify potential concessions. Furthermore, I explore compromise options by testing ideas, sharing different scenarios, and educating all participants on realistic legal remedies and barriers. Having navigate countless disputes allows me to propose creative options more parties may not initially see. Transparency, cooperation, and maintaining open communication channels are equally important. I make sure discussions continue moving forward productively through respect, privacy, and documenting any incremental progress reached. In summary, these carefully planned settlement negotiations aim to replace arguments with problem solving. Acting as a lawyer but also facilitator, my role guides my clients towards the most satisfactory outcome available given legal constraints and each side's ultimate business interests and needs. With that, we have now covered the negotiation process itself as a key part of my hybrid dispute resolution approach. Now that we've discussed initiating negotiations and the mechanics of the actual settlement discussions, let's shift our focus to the goal of these talks, reaching a mutually agreeable resolution. As the parties engage through the negotiation process, be it direct discussions or mediation, an important first step is acknowledging each side's perspective through respectful dialogue and open exchange of evidence and arguments. My role helps guide productive conversations between all representatives. With a full understanding laid out, the real work then turns to problem solving. As the legal advisor, I will look for compromise positions and creative settlement options that bridge different interests and satisfy parties' needs to the greatest extent possible. Flexibility on smaller details and some degree of concessions are usually required from both sides to get to that win-win agreement. Through my experience navigating these situations, I aim to propose balanced deals whenever attainable. When broad consensus starts taking shape around core terms, it's time to document key points like payment amounts, responsibilities, and next steps going forward in a brief term sheet. While not binding, this records the tentative resolution reached. Throughout this intensive process, my priority is protecting my clients while guiding negotiations towards the most practical and fair outcome given each unique circumstance. With cooperation on all fronts, disputes can efficiently transition from accusations into new business partnerships. Once the broad terms gain approval, legally enforceable language is drafted into a settlement contract. At this point, it is important to formally document the settlement in a legally binding contract. As the party's lawyer, drafting a comprehensive settlement agreement is core to my role. In our agreement, I will precisely outline all obligations and actions agreed to by both sides. This includes specifics such as payment amounts and schedules, any asset transfers, releases from liability, confidentiality clauses, and consequences for breaching the terms. Ensuring remedies are clear is crucial. The contract language must reflect the understanding reached and offer recourse if issues arise going forward. I'll also address any ongoing relationship between the parties post-settlement. Before finalizing, I will review the draft agreement with my clients to address concerns or conduct additional negotiations if needed. Transparency is key to make sure interests are properly satisfied. Once all approvals are obtained, the settlement becomes legally enforceable through the courts if a party does not comply with the contracted terms. This provides the certainty needed to reasonably close the dispute. By taking the extra step to formalize our out-of-court negotiations, risks are mitigated for both sides. My legal experience in crafting these types of agreements efficiently concludes the settlement process. Let's review the key advantages it can provide compared to formal legal processes like litigation or arbitration. Firstly, settling disputes outside of the courtroom allows for a faster resolution overall. By directly negotiating, parties have more control over the pace and can potentially reach agreement more swiftly than going through protracted legal procedures. This leads to potentially lower costs as well. Avoiding lengthy legal filings, motions, hearings and other formalities that drive up solicitor fees means a negotiated solution may end up costing less for both sides in total expenses. Parties also retain autonomy over crafting the resolution. Whether it be a payment arrangement, business partnership, or other innovative solution, those involved can design a customized outcome better tailored to their unique needs and interests. Compared to a rigid court remedy, early settlement fosters creative agreements addressing the root issues in a holistic manner. This improved satisfaction can even salvage business relationships while litigation poisons dynamics. Additionally, negotiations maintain confidentiality of resolved disputes that otherwise become public record through legal docketing. Sensitive commercial information stays private instead of fueling further damage. Of course, settlement flexibility comes with narrower remedies than formal adjudication. However, as a hybrid approach, entering cooperation allows abandoning costly adversarial tactics before truly required through preparing your rights while preserving optional relief should cooperation prove impossible ultimately despite sincere efforts. In summary, out-of-court resolution maximizes efficiency, control and discretion when possible. My role is help guide meaningful discussion towards mutually agreeable outcomes whenever reasonably aligning with your interests and legal entitlements to claims, thereby providing optimal value. Now that we've covered what constitutes a potential legal case, let's discuss alternative approaches for resolving disputes outside of the court system. One such option is arbitration. Arbitration is a formal alternative dispute resolution process where disputing parties agree to have their case privately adjudicated by a neutral third-party arbitrator instead of going through litigation. Where disputing parties agree to have their case privately adjudicated by a neutral third-party arbitrator instead of going through litigation. It provides a confidential and often faster means of resolving conflicts governed by Chinese arbitration law and overseen by specialized arbitration institutions. One of the most essential prerequisites for arbitration is the existence of a valid arbitration agreement between the disputing parties. This agreement indicates both sides' consent to resolve any future disputes through arbitration rather than litigation. An arbitration agreement is a written clause within a commercial contract stating that any disputes arising from the agreement will be resolved through arbitration rather than litigation. It indicates both parties' consent to private arbitration if issues emerge in the future. This agreement is absolutely critical. Without it, a party cannot later compel arbitration. The dispute would default to courts. The clause must be incorporated into original contracts to establish the legal foundation for arbitration later on if needed. To be valid, arbitration clauses must be in writing, clearly articulate that future disputes go to arbitration, designate the arbitration rules and institution, name the arbitrators if applicable, and include authorized signatures of both contracting parties. Summary. In conclusion, properly drafting the arbitration agreement upfront when creating contracts is essential to reap the intended benefits of private arbitration down the road, such as reduced costs and timelines. Establishing this prerequisite is fundamental for the disputes process. The arbitration process in China typically involves choosing an arbitration institution, appointing arbitrators, submitting claims/defense documentation, hearings where arguments and evidence are presented, examination of evidence/witnesses by arbitrators, and ultimately an arbitral award being rendered. Let me walk through some of these key steps in the procedure. 1. Choosing an arbitration institution. The first step is selecting the arbitration institution that will administer your case. In China, some of the major options include SIATAC, BAC, Shanghai Arbitration Commission, and SCIA. Each institution has its own rules and procedures, so it's important to research and choose one that's suitable for your industry and type of dispute. 2. Submitting claims and defenses. Once an arbitration center is chosen, the claimant files a written request for arbitration along with supporting documentation of their claims. The respondent then responds with their defense and any counterclaims within the required timeframe. All submissions are shared with the opposing party and arbitration institution. 3. Appointing arbitrators. The arbitration institution will appoint either a sole arbitrator or three-member tribunal depending on the case complexity. Qualified arbitrators have expertise in relevant industry and legal matters. Their role is to fairly and impartially resolve the dispute. 4. Hearings and evidence. Next, a schedule is set which may include oral hearings conducted in person or virtually. Each side can present key evidence, examine witnesses, and argue their case before the arbitral tribunal. The arbitrators also examine proof, question the parties, and carry out inspections when necessary. 5. Final award. Finally, after carefully reviewing all case materials, the arbitrators will render a final and binding award within the set timeframe, usually 3 to 6 months. This decision addresses all dispute aspects like damages, costs, remedies, and more. Awards are enforceable through domestic courts. I hope this high-level overview helped explain the basic arbitration process here in China. In addition to arbitration, another option for resolving disputes is litigation, which involves taking a case through the formal court system. Litigation refers to the legal process of having a dispute resolved by a court of law through a civil lawsuit. One party brings a complaint as the plaintiff against another as the defendant, with the goal of the court rendering a binding judgment. The litigation process typically involves filing a lawsuit, court review, submitting evidence, potential pre-trial settlement talks, a court trial, and finally a judgment being issued. Let me briefly outline some of these main stages. Stage 1. Filing the case. The first step is to file your legal complaint and supporting documentation with the appropriate people's court. This initiates the legal proceedings. Stage 2. Court review. The court will then review your filing and decide whether to accept or docket the case based on jurisdictional and procedural requirements. Stage 3. Evidence submission. Both parties must provide all relevant documentary evidence and witness statements to the court by the specified deadline, which is usually within 1 to 2 months of case acceptance. Stage 4. Trial. The trial involves oral arguments from each side's lawyers before a panel of judges. Witnesses may also be questioned. Trials are typically concluded within 6 to 12 months. Stage 5. Judgment. Finally, within 2 months of the trial conclusion, the judges will issue a written ruling to decide the outcome of the case and remedies, if any. Losing parties can then appeal aspects of the judgment. In our previous section, we discussed the different options available for resolving legal disputes, out-of-court settlement, arbitration, and litigation. Each approach has its pros and cons depending on the situation. That's why here at our law firm, we recommend a hybrid model that combines the strengths of multiple strategies. Our hybrid process is tailored specifically for our clients' needs. Let's walk through how it works. First, we conduct a thorough assessment of your case by gathering facts, documentation, and performing due diligence on the other party. This allows us to fully understand the merits and scope of your claims. My team and I will want to discuss your matter in depth. This involves gathering documentation of agreements, payments, correspondence, anything related to the issues. With this information, our legal experts can begin due diligence. This means investigating the other party through official records and databases. It's important we know their business history, financials, and validity. This stage allows us to evaluate the strength of your position. Now equipped with the facts, we can craft a demand letter clearly outlining your claims. This formal notice goes to the other side requesting resolution. With our case preparation, we are in a strong position. But we start by attempting to resolve the matter through our hybrid process early stages, negotiation and mediation. Through correspondence and possibly mediation, we try finding an agreeable solution. These less formal approaches can sometimes result in an agreement, if all sides are willing. If negotiation is successful and the parties can come to an agreement, we will draft a legally binding settlement agreement to memorialize the terms. This contract clearly outlines obligations, timelines, and consequences in an enforceable manner. It brings finality and prevents future disputes over the resolution. Our lawyers are experienced in crafting settlement agreements that protect our clients' interests. We take into account things like ongoing business relationships, non-admission of liability, non-disclosure clauses, and payment schedules. Once signed, the agreement concludes the matter efficiently and allows both sides to move forward. And they have significant benefits over immediately going to arbitration or litigation. Compromise at this stage prevents escalating costs and maintains business relationships, if possible. But we don't stop prepping your legal defense. However, if negotiation and mediation are unsuccessful, we are ready to transition seamlessly into arbitration or filing a lawsuit on your behalf. All prior work fortifies your arguments. Our legal case preparation gives you leverage throughout the entire process. With this hybrid model, you have both flexibility and power over your dispute. You maintain control based on the specific circumstances. And either way, you have a committed legal advocate on your side, thoroughly prepared to represent your interests. In summary, our tailored approach takes the best elements from different strategies to suit your unique situation. Let me know if you have any other questions. I'd be happy to further discuss how we can help resolve your dispute. We've now reached the end of our overview on using a hybrid process to resolve legal disputes strategically. I hope you've gained valuable insights into our tailored multi-step approach. To wrap up our discussion, I'd like to summarize some key takeaways from today's seminar and provide next steps. First, we covered understanding the concept of a legal case in China and what qualifies a dispute as valid for resolution through the legal system. Having a clear agreement, damages incurred, and evidence documented are essential. We then explored effective dispute resolution strategies, looking at options like negotiation, mediation, arbitration, and litigation. As I explained, our hybrid model combines the benefits of different approaches for tailored solutions. A major advantage is maintaining control over your dispute while having legal expertise every step of the way. You can attempt less formal resolutions first before transitioning if needed. This hybrid process is ultimately designed for flexibility based on individual circumstances. So in summary, formalize agreements, gather evidence, understand your rights, and utilize a multi-pronged strategy for the strongest position. Taking these proactive steps will put you in the driver's seat no matter where discussions lead. At this stage, the best next step is to book a consultation with our legal team. During our meeting, we can thoroughly discuss the specifics of your case. I'll want to learn all the details, review any documentation you can provide, and ask you questions to fully comprehend the nature of the issues. This information gathering is so important. With a comprehensive understanding of your matter, I'll be able to assess the strengths and weaknesses of your potential claims or defenses. We can analyze the other parties and the legal landscape. From there, my team and I will outline a customized strategy and resolution plan. We'll provide estimated timelines and costs to manage your expectations. Importantly, the consultation allows us to address any questions or concerns you have. I want you to make an informed decision on the most suitable next steps. Taking action by booking this consultation is the key to progressing your case in a prompt and organized manner. So please contact my offices as soon as possible to reserve a time on our calendar. Our consultation slots do book up quickly. But speaking directly with our experienced legal counselors is the best way to draw on our expertise, gain clarity, and begin building momentum to resolve your dispute. We look forward to assisting you through every facet of this process. So get in touch, our door is open to help you in any way possible. Thank you.